professionals, we often find ourselves deeply connected with associations that aim to uphold standards, foster collaboration, and give members a collective voice. But what happens when the goals of these associations begin to intersect or even clash with our individual rights? It's a delicate balance, aligning collective purpose with personal freedom. The real question is, how do we make sure that institutional power supports rather than compromises the autonomy we each hold as professionals? To help us explore this, we are joined by two thought leaders who navigate both professional and legal landscapes with remarkable clarity and insight. First, we have Dr. Puranchand Chhabra, an advocate with a truly unique background. He's also worked as a veterinary microbiologist and an insurance executive, bringing a rare blend of scientific, administrative, and legal experience to the table. And joining him is Dr. Bhuvan Nagpal, a familiar name to many of you. He's an oral pathologist, legal consultant, and someone actively involved in both oral pathology practice and advocacy. He's also the founding president of POPMA, the Practicing Oral Pathologists and Microbiologists Association, a platform that supports and represents professionals. Welcome, Advocate Chhabra and Dr. Nagpal.
Thank you.
It's wonderful to have you here with us. So let's dive in. Our first question is just to sort of set the background and to let us know what the things are. And this one is to our Advocate Chhabra. So, could you help us understand the difference between an association, a society, and a union?
See, the concept of unions, it existed even in British time, and the associations also existed. Unions, basically, they are made by the workers, so that they can collectively bargain for wages, better work environment, and against any exploitation by the uh, employer. Whereas associations, they are made by the professionals, and their objective is to promote more interaction between the members of the same profession, improve the professional knowledge, and then some time to interact with the administrative authorities or executive authorities to bring certain changes in favor of the professionals. And if there is something which is looming large against a profession, that can be stopped. So there are, associations in every field. Like for the medical profession, Indian Medical Association is existing since I think 1928 or something like that. And for the chartered accountants, there is another association. The associations are all registered under the Societies Act. The societies sometime may be for a may be made by a particular group, need not be professionals. But once we talk of associations, it has to be a group of professionals. So that is how we distinguish between these three terminologies.
Thank you. Yeah, that's very encompassing. So essentially, between the three, if we think about unions, societies, and association, the literally everyone is covered. It's like anybody has a right to create or to attend one. In fact, I think we have a constitutional right, which is the freedom of association. So can you tell us a
Yes.
little about that?
Yes. See, in our constitution, there is a chapter of fundamental rights. And in that chapter, there is a chapter of, there is an Article 19. And under that Article 19(1)(c), every citizen of India has a right to form association. So why the associations, this has been made a fundamental right is so that they as collective, union, collective group, not union, collective group can interact, can form association for betterment of their profession and to curb if anything is brought against the profession as such. Then in every association, when we form an association, we have a list of members. Then we have, the association has to be run by elected representative, because we are a democratic society, democratic country. So the association has to be run by the elected representatives. The According to the bylaws of each association, the elections are to be held either after 1 year or 2 year or 3 years. Like in our associations at the bar council level, the election is every year. But in some of the societies or associations, it is 3 years, but nothing more than 3 years. 3 years is the longest period an association can have for election.
So, in a way, I think all these associations are a reflection of our broader democracy, which is the national democracy, the country's
Yes,
democracy. These are literally reflecting that exactly within the system.
yes,
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 it is really what makes I think the country and everything in it very strong. But now, are
yes.
there any limitations where anyone or any group or anyone cannot, start an association?
There is nothing in, because it's a fundamental right. Like Indian Medical Association is there. But in addition to Indian Medical Association, there is an association of specialists. So there is no such restriction. The only thing, even the associations are not covered by the Trademark Act. But generally, when an association is existing by a particular name, so it is advisable to avoid confusion. There should be no other association by the same name. It is just for the sake of avoiding confusion.
Mhm.
Like we have bar association, but for every district there is a separate bar association. For my hometown, Hisar Bar Association, in a neighboring city, Rohtak Bar Association, only for distinction. But even a member who is member of Hisar Bar Association can become a member of all the state bar associations. There is no restriction.
Very interesting. Yes. And I think, I mean, Dr. Bhuvan knows, I think, because he's a member of many associations, that in our field, I think in pathology, for example, we know there are many, many associations of pathology. Dr. Bhuvan, I think you had checked at
Yes,
one point.
yes. Greetings, everyone. Yeah, thank you so much, Dr. Mandana, for inviting me again as one of the panelists. Yeah, there are many associations, ma'am, for pathology and even for specialty also. Like in general pathology, there is an association by the name of IAPM, Indian Association of Pathologists and Microbiologists. Then they have International Academy of Pathology, India Division, and this IAPM also has many state chapters. Then we have Association of Practicing Pathologists India. We have Association of Practicing Pathologists Haryana, Delhi, and then Society of Practicing Pathologists Rajasthan, which is again a national level organization. Then many are there. Even I've
Many
got
of
to
the
know that the Pathologists Association is also there
Yes,
recently.
I do know because I'm also a member of a couple of those. So I do know that at least pathology definitely has a number of associations. So this is a very interesting thing, which means basically there is, to make it a very clear statement, is there is no legal barrier to forming or joining lawful associations in India.
Yes,
So,
true.
so this is clear statement.
It's
There
a
is no
basic
confusion,
fundamental right.
right? Yes. So, what about when say you are a member of an association already, and for whatever reason that association may want to decide as to where its members may learn, contribute, or participate, whether it's a forum or a club or a platform outside the association. So Can any organization limit its members from taking part somewhere else?
No, well, that is again a fundamental right to profession and avocation. So nobody can restrict. The only thing is, so long as you are in the same profession, there may be some restrictions, like a person who is in medical profession cannot practice law, or a person who is in law cannot practice another profession. But within the same profession, there is nothing which stops a person from becoming member of any number of association, getting training or imparting training, or even a person can be executive member of more than one association. So there is nothing which stops.
True. So this next question is to you, Dr. Nagpal.
Yes.
Now you are already leading an association. So have any of your members ever felt that in any way worried or disturbed, whether by participating in another association or another platform or another venue, whether they are being disloyal to, say, POPMA?
No, ma'am, we didn't had anything that you cannot be part of any other association, because it's a fundamental right. And as a legal consultant, I can work as a in the capacity as a legal advisor, because I'm not registered with Bar Council of India. Um, so we have never restricted, because even myself, I am member for 28 different medical, dental, biochemistry, general pathology, and oncology. So there are so many associations, and there they have kept provisions where even MDS oral pathologists, they can become member. Rather, there are so many societies where they have restricted that. The ambiguity was there in terms of the qualification. But when I have written letters, so they have accepted that thing. So now it has come in writing also, that you can be a part of that. So pertaining to that, there is no restriction from POPMA's end, that to our members, that they cannot be member of other association. They are free for that, because it is their fundamental right.
Very correct. So basically, besides, as we saw, the freedom to establish an association or a group, there's also the freedom to engage and grow professionally. Again, does not disappear just because one is a member of a larger group. So that does not disappear. You cannot be told not to learn somewhere or not to work somewhere or not to do something. These are all very interesting, and those boundaries and those limits have to be really maintained. So now, but of course, so this sometimes extends. Now, what about, because associations, of course, have their own bylaws. So, can a bylaw, an association, use its bylaw or the voice of majority by saying, the majority of our members today believe that an action should be, binding to everybody within the association as a whole? So, can they use that to say, for example, ban a certain entity or a certain association to their members?
No, no association or society can ban any member from joining another association. Even if some bylaws are made in this respect, these can be challenged. Because this will be in infringement of fundamental rights. And even if the general body approves it, they are still subject to scrutiny, because the constitutional courts are there only for this purpose. Thus, none of the citizens' fundamental rights are infringed.
Yes. So, and another follow up. I know it's in a way a repetition, but just to be clear, there is sometimes, in certain write ups or certain things we see that an association or even sometimes entities, I guess, will insist that the person cannot or should not approach a court of law and should only seek resolution internally. Is that legal or is that acceptable?
See, They can put a condition. But even 1972, Mrs. Indira Gandhi, she had put 42nd Amendment where she had stated, in the amendment, the parliament had stated that the Supreme Court or any constitutional court has no right to review the law. Even that was struck down. So if the something which is done by the parliament and approved by both the houses and even notified after consent from the president, if it can be struck down, how can the association, make such a law?
True.
Even if the if any law is made by the parliament that said you cannot go to a court of law, then what is the alternate relief given? It cannot be that if the association is sometime run by a person is of dictator type, so then how the association will run? It will be one man's show, and where the members will go. So they have to have their rights protected. And for that, the members can go to the registrar and express whatever they have in their mind, that what right is being infringed upon. But any fundamental right, if it is infringed, then High Court and Supreme Court is always there to protect those fundamental rights.
Yes. Now there is one more question, and this I will put to both of you. Supposing, an association, let's say a person has joined an association, like I have been member of certain associations almost for the last 30 years. So when I joined, the rules and regulations were different. Today, with the passage of time, the rules and regulations might become different. And I may no longer agree with those rules. Now, they may tell me, and maybe I find that they are fundamentally not correct. So, of course, anyone may say, but what is the big deal? Why don't you just leave the association?
Yes, anyone who is not agreeing with the association's bylaws, if he feels that the bylaws will not be interest of the members or it will not be in the interest of profession, he can simply walk out. Nobody stops him. But sometimes it is not good to walk out. It is better for the fraternity to tell the persons what is correct and make others stand with you and get the right things done. So if I simply resign from the association, that means I am, not protecting my own right. The better way is in association also, a group can move agenda that this is not correct, and let us have meeting of the general house and get the things corrected.
Correct. Yes. Yes, absolutely. Because I also think, I mean, besides the fact, it's a thought that essentially anyone who has been a member for whatever period of time, I think has an inherent right now to that association. Because
Yes,
obviously, by being a part, you have supported the association. Even the most inactive member, by virtue of having, lent their name or their support, have in some way become a stakeholder in the association. So just to say that if you don't like it, walk out would not be appropriate.
yes.
I
I
think
agree with you 100%.
Yes.
I totally agree with Advocate Chhabra sir that it will be like an autocracy which is happening, which any law which is autocratic in nature is stopping your fundamental right to do something which is bound by the laws of natural justice. So when we are living in a democracy, so we are being member of an association for so long, we have paid the dues, we were part of that association. So if something wrong is there, I think that should be fought for that, because otherwise, and the same applies to our country also, many people, the reforms have come only when the wrong things have been challenged. That is other thing, that they are not being challenged many at times, But when they have been challenged, like you can see the case of smoking in public places, the smoking used to be there, but one gentleman took this thing and put a PIL, public interest litigation, and after that smoking was banned in public areas. I hope, sir, I'm right in that way, because
Yes, yes.
so
Yes, that's true. And I think essentially when it comes to when we say the rights of association, the rights of a group, uh, you know, this idea might be there that by stopping another group or by stopping people being a part of another group or association, we are keeping unity, we are keeping purity, or we are keeping our strength, or n number of excuses and reasons can be given. But I would think that through history, probably every reason that could be tried has been tried to keep somebody out or somebody in something. And I think whether it has been by race, by color, by religion, by gender, everything has been tried, and I believe that all of it has failed. Bec- I mean, that is my understanding of whatever I have read, and I have seen that nobody has ever really won a case where they have tried to limit this right to association.
True. Even small, small things give, pave the way for good legislations. The Right to Information Act was not there. Anna Hazare took it onto him. And finally, it came in 2004 and 2005, it was notified. So things do change. And that is because of some persons who have the courage and conviction that I am right and I will get it done. So those diehards, they change the destiny of nation.
That is true. And we have to be grateful for those, definitely, for all the hard work and all the difficulties they have faced. Now,
yeah,
going on,
even
yeah, yes, Dr. Bhuvan, you wanted to
even
say
I
something.
just want to quote one judgment. It was for the Cine Artists and Hairdressers Association, which was in Mumbai. So in that there was a clause that females cannot be member of that association, and those who are members, they have to be like part of Mumbai. They have a residential proof for staying in Mumbai for 5 years or so. But this was challenged in the Supreme Court because they said that all are equal as per the Article 14, and then it was quashed. It was one of the bylaws only. So because it was pertaining to the bylaw, so I thought I should mention this aspect also.
True. But now, sometimes, of course, associations also should be protected. So, if something is wrong, or if they have a problem with anyone for whatever reason, what are when it comes to disciplinary actions, what are the legal options available to an association?
See, if there is any disciplinary action to be taken against a member, then the executive committee, because all the things are to be done by the executive committee, and all the meetings of the executive committee are to be recorded compulsorily in the meeting register so that there is a complete record. The verbal orders of the president or just secretary or joint secretary, they cannot be implemented unless the executive committee by majority agrees to the proposal, and that should be there in the agenda, and the minutes have to be recorded, and the register where the minutes of the meeting are to be recorded is one on the front page of which it is written that this register consists of so many pages and all pages are to be numbered, and the minutes of the meeting are to be recorded in chronological order, and the register has to be maintained for n number of years. You cannot destroy the this register which is recording minutes of the meeting of the executive committee. So if any action is to be taken, first it will be circulated amongst the executive committee members through a circular. The meeting may be in the physical form, or maybe online, or maybe by circulation. Then all the executive members have to either agree to a particular action, or may suggest modifications, or have a right to completely disagree. So to the modification also, the person who has mooted the agenda, generally it is the secretary, he has to include, and if he feels yes, modification is needed, he can come with a new agenda with modification. And then that is, if that is approved, then it becomes the decision of the executive committee, and then action can be taken based on that decision of the committee.
So, Dr. Bhuvan, in POPMA, what sort of disciplinary actions have you got in your bylaws, or what have you foreseen as possibilities?
No, as such, we have not mentioned anything for the disciplinary action. But whatever the decision which we make is part of our governing body. Governing body and executive committee are the same. It's just the terminology difference. And in POPMA, we have 7 members. There are 2 executive members, the president, secretary, uh, vice president, joint secretary, treasurer, and 2 executive members. Along with that, with a special resolution, we have made 2 posts. One is for the auditor general, and one is for the chief of state representatives, because we have members from over 20 states and union territories. So as of now, because it's a young association, we'll be completing 2 years in 2000 in October 2025. But we make sure that everything is being done with a proper legality, because it is registered. We have a registered office. Everything is displayed. All the registers are maintained every year. Before 31st of May, all the financial details, all the income tax returns, and all the details of the members are being given. So we follow as per the Haryana Registration and Regulation of Societies Act 2012. So all those things are being, and as of now there is no need, and probably if need arises, will try to solve and the grievances. But we have a committee, that is a grievance redressal committee in our uh, um, association, that is POPMA. And for that, chairperson is there, and I'm also part of that committee. So in that grievance, either pertaining to the society affairs, the association affairs, or in general as a whole, if they face any problem, because association is a union of members, is a union of people who are working for a common cause. So if they face any issue, whether promoting for their cause, be it in their routine life or anything, for that matter, suppose if somebody says, oh, oral pathologist you cannot sign, or some defaming kind of words being said for particular profession, so we can always protest peacefully for our existence, because freedom of expression does not mean that you start demeaning others. It means that you can tell the truth, what is truth, and in a proper way. I think these are the things, ma'am.
Right. Good. Okay. So, coming back to our disciplinary actions and societies. Now, of course, one of the, I think, possible disciplinary actions that any society or association may take may be to remove members. But I feel that would be, like a very last, the final step, or the most serious action that anyone could take against a member. Would there be any safeguards against such things?
Any action, first thing is that it has to be approved by the executive committee. The society can suspend the membership for a short period, can uh, you know uh, put a fine, or the last resort, in a very very severe or misconduct, the person can be removed. But then it cannot be done without giving him an opportunity of being heard. And once the person responds to that, because Ashoka's notice has to be given, and each and every point has to be seen by the committee from an independent angle, irrespective of the fact that the committee has approved the action. Sometimes the committee members may not be aware of all the facts, and when the person responds, then they come to know of all the facts and they have a right to change the decision. And in many cases, even in the employer employee relationship, when the employee gets a show cause notice, after that, the show cause notice is simply removed because his explanation is found plausible and correct. So there is no hard and fast rule that once the show cause notice is given, action has to be taken. So it depends upon the facts of each case. And then that committee has to, with a neutral mind, study the response and then take an action.
Very, very true. Yes, I guess it's very natural, and it is actually within the word itself. Show cause notice. It tells you to show cause, and if you have shown enough cause, I guess it should be withdrawn. Yes, that's a very logical answer, actually. Yes. So, of course, now when we talk about disciplinary actions, removal, or whatever it may be, there is definitely a possibility of either a member going to court or the association going to court for whatever reason. Now, if that happens, obviously any action would have been signed through the EC, and everybody, or at least the majority, should have been party to it and should have accepted that action. In which case, what is the stand of all the EC members? Can they be called to court while the case is proceeding?
See, if anybody is challenging the decision of the EC, all those members who have voted in favor of the action, they are bound to explain their conduct in a court of law. And that action sometime may not end with the removal of a member. Sometimes the action may result in a defamation of a person. It is not that simply we have removed a person. It brings a slur on a person. His reputation is tarnished. So the person has a right to institute two type of cases. One is criminal defamation, other is civil defamation. In criminal defamation, all the persons who have caused defamation and published means circulated.
Okay.
If I abuse somebody or say something which is not correct to him in a closed room, he cannot go and file a case against me for defamation because I have not circulated. I have addressed to him only. But if there are more than one person, one additional person is there, then it amounts to publication because more than one person has come to know of it. So, but the other protection to the person against whom the defamation suit or defamation case is brought is that if it is based on facts, then he has a protection. But if he cannot prove that it is fact and in the larger interest of the public, then he has to face the consequences.
If you allow me, ma'am,
Yes,
just two
please.
minutes,
Yes.
I'll give one more example which I have faced in my real life. That we, you know, that I work in a lab, and regularly the viral markers are being done. So one lady who came out to be HIV reactive. So we have a protocol that we give the report in a sealed envelope. So she was in emergency, and the hospital staff has opened that report, and publicly they started discussing. That lady has sued the hospital for criminal defamation.
Yes, she has a right.
Because they,
That even if it is fact,
Okay.
then criminal defamation suit can, a case can be filed.
yes,
It
yes,
cannot be said that it is in public interest.
they have tarnished that image,
Yes.
no, and it
Yes.
has to be. And we have a specific law, that is AIDS Act 2017.
Yes.
So
Yes.
under that there are so many provisions. So uh, this is the thing. So as sir has rightly
Yes.
mentioned, that when we are saying something, so it has to be based on
Mm.
facts.
Yeah, I know. I mean, like we think about this of defamation in a very general and I guess a superficial way. We don't think of the depth and the how broad it can be. We don't really think about it. This is very interesting and very
Can
important.
I ask one thing, sir? Sir, can you differentiate between the whistleblowing, somebody who is telling that such wrong thing has happened in a particular context? So, will that also amount for defamation?
No, whistleblower has protection. In fact, he is doing something good for the society and the nation, because otherwise the things will remain concealed and the damages will keep on increasing. So, whistleblower, in fact, by whistleblowing, is stopping the damages at a particular in- time. That look, this person has done this, please take care. So it is for those persons who are responsible to act and see that the whistleblower is protected and action is taken. Most of the cases, especially financial frauds committed by the managers in the banks or in associations or in even resident welfare associations, they come out because of the whistleblowers. Otherwise, people do not come to know for years what is happening.
Very true. Yes. And I guess the thing with the whistleblower is it will be, I mean, they're bringing to notice something that's true.
Yes, whistleblower term is used only if he is giving the true information,
Yes. Correct.
Not for gossip, not for
Mm.
wrong information.
Correct.
If I write to the say Central Bureau of Investigation about something which is not true, and they start acting on it, so I if it is the information is found to be untrue, I can be sued for invoking the process of law in a wrong manner. So we call I have misused the process of law.
Right. Okay. So let's segue back to the what associations can do. Uh, Now, of course, like in India, of course, we have many tiered legal system, and there is always a opportunity to go higher up. But this also can mean that a litigation can keep on going. Now, are there any limits on how far an association can go with a litigation?
See, everything has to be written in the bylaws, that how much funds the association can spend on what, in what form, and who can authorize. Like, suppose I'm a professional association, say medical profession. I want to publish some journals. I want to hold some melas for, you know, not for publicity, but for awareness. So the funds have to be allocated and approved by the committee. Maybe the committee has given some authority to the president that up to this particular amount in emergency you can use without coming to us. Beyond that, everything has to be approved by the executive committee or governing body, whatever it is. But as such, there is no limit that how much amount can be spent on what litigation.
So
But in
basically,
societies, there is no such specific limit given in the act.
okay, the act doesn't have it, and I guess they
Yes,
hope that the individual association will set it in their own
yes,
bylaws. Yes.
yes.
But of course, I think at this point of time where we are, what you would say, in a very litigious society, and there's a lot of possibility, and of course, naturally, people should fight for their rights, and even associations should protect their own rights. So the possibility can be endless, and definitely, I think associations should take this on board and have a plan in place as to how far they will go, how much they will spend. These are all very important matters. So I think we have come almost to the end. We have covered a number of things, but just in case I have missed something that you think is important in this context, let me ask each of you to give me any thoughts you have. I'll ask you to go first, Dr. Chhabra.
See, whenever any association is made, when the bylaws are made, it is important that the bylaws are made not for punishing the members, but the bylaws are made for more open discussion by the members and for the betterment of the members. And the association should be democratic, and there cannot be democracy without dissent. So dissent should always be encouraged, because my viewpoint can be different from that of others. Unless I accept the other's viewpoint with an open mind, I cannot improve myself, because I am carrying a notion which is wrong, but nobody has told me that it is wrong. If somebody tells me and then I look at it from his viewpoint, maybe I will change my opinion, and maybe I will salute that person, that my notion which was wrong for 10 years or 20 years has been corrected by somebody who had the courage of telling me that what you were doing for last 20 years was wrong. So that is more important, that the bylaws should be such which encourage participation and especially dissent.
Very true. Very true. Yes. Very good point. Yes. Dr. Bhuvan.
Yes. Uh, yeah, ma'am. I will conclude with two, 3 points. One, association is made to promote a particular branch or particular goal with which all members have joined. So we all have a common goal, and that goal should be the priority instead of that medium, because association is just a medium to achieve that. But we have certain protocols and professionalism which we have to follow. And bylaws are legally enforceable provided they abide by the laws of the land. These are my thoughts. Association should always follow inclusivity rather than exclusivity, because that is more important. If we think that we are only exclusive, I think the growth will not happen. So everybody will live in India, and India is a republic, and we are in a democratic country. So everybody's opinion and rights should be acknowledged and should be taken with an open mind. That's all now. Thank you so much.
Thank you both. Yes.
Thank you, Dr. Mandana. We had a fruitful discussion, and I hope we will have such discussion in the future as well.
Definitely.
Thank you
This was
so
just
much.
one aspect of the way a society or an association can, the intersection of an association with the fundamental rights of its members. But there's so much more that we can talk about, and so much more that can help us grow. And we would definitely look to having you with us. Uh, I don't know whether to say Dr. Chhabra or Advocate Chhabra. I guess both is correct.
Yes.
Yes.
Both are correct.
Both are correct, yes. And of course, Dr. Bhuvan is essentially a part of our own setup, and he is always there. So let me just wrap up with saying that for everyone watching this is that our discussion was really not about any one association, although we had a representation from POPMA here. It was just an example. It was really about the principles, the principles that protect us as individuals, preserve the trust we have between each other, and help the associations that we look to or that we are a part of, that help us to grow as a collective, to serve the members, and to be a strong and valuable part of our professional scene. There are many opinions. This was not meant to be an exhaustive view of everything about an association. There's much more to be said, much more to be discussed, and we will definitely get together and talk about those too in time. If you have any ideas of other things you would want us to discuss, you can always put it in the comments.
Thank you.
And we certainly hope there will be many more conversations on many more topics. Conversations are the way to grow and improve. Thank you so much.